Civil Procedure Code, Unit 1. So the first important concept in Unit 1 CPC is jurisdiction of civil courts. So what is the meaning of jurisdiction? Jurisdiction is the authority of the judicial officer to entertain, deal with and decide the list or suit before him. So it is the authority of the judge or the judicial officer to entertain the suit or decide the suit before him. It is called jurisdiction of that judge, judicial officer. Case law. Official trustee versus Sachindranath. So in this case it was decided that jurisdiction includes power to hear and decide the question at issue, authority to hear and decide a particular controversy arising between the parties. So it is both to decide the issue and to hear the issue. Kinds of jurisdiction. We have first civil and criminal jurisdiction. So for civil we have disputes of civil nature, and criminal the crimes are punishing the offenders. It is crimes and punishing the offenders. The next is a territorial or a local jurisdiction. So for this the government sets the limits of the territory for different courts. So district court can decide within its jurisdiction, and within the district, and high court can decide within a state its jurisdiction. The next is pecuniary jurisdiction. So this jurisdiction is to the amount or value of the suit. So amount or value of the suit subject matter not exceed the pecuniary limits of the court's jurisdiction. So every court has its pecuniary limit to try the suit, the amount it can try. Like JMFC has its different amount, and senior division has its different amount it can try. It's called pecuniary jurisdiction. The next is jurisdiction as to the subject matter. So different courts are empowered to decide different types of suits. For example, a district judge or civil judge can decide on divorce cases, testamentary matters, probate proceedings and insolvency proceedings only. Like that, different courts have a different power to decide the suit on different subject matter. The next is original and appellate jurisdiction. So original jurisdiction is conferred upon courts on first instance. So suits, petition and applications. While the appellate jurisdiction is the power of superior court to rehear by way of appeal. So in the original court we apply the main suit, and in appellate court we apply appeal. The next is exclusive and concurrent. So exclusive is sole authority, while concurrent is triable by different courts. The next is general and special jurisdiction. So in general jurisdiction we have all cause. For all cause we can file the suit, and in a special courts we can apply for special cases or cause only. And the next is legal and equitable jurisdiction. So legal is for common law courts, and equitable is equity courts in England. Municipal and foreign jurisdiction. So municipal is local courts, and for foreign courts. Expounding and expanding. So expounding jurisdiction is where they define, clarify and explain the matter, while expanding is expand, enlarge and jurisdiction. So this is jurisdiction of the courts and kinds of jurisdiction. The next important matter is jurisdiction of civil courts, section 9. So what is this section 9? Courts to try all civil suits unless barred. So courts has the power to try all civil suits unless their cognizance is expressly or impliedly barred. So what does it mean? Conditions. Suit must be of civil nature first, and covers private rights and obligations of the citizens, and not covers political and religious questions. So first condition is that the suit must be of a civil nature. So civil nature means that covers the private right of a citizen but does not cover political and religious questions. Case law. Most rave PMA Metropolitan versus Moran Mar Marthoma. In this case it was held that a dispute affecting one's rights are not only of civil but of civil nature. The next condition is cognizance of such suit should not be expressly or impliedly barred. So expressly barred means by an enactment time being in force, and impliedly barred means by general principles of law. So this is section 9, jurisdiction. The next important matter is res subjudice. So what do you mean by res subjudice? Section 10. So what it says is that if a plaintiff files a suit in a court, competent court, and that court is has a jurisdiction and competence to try it, then the same plaintiff cannot file this suit in another court during the pendency of that suit. This is called res subjudice. So no court shall proceed with the trial of any suit in which the matter issue is also directly and substantially an issue in a previously instituted suit between the same parties. So it says the same section that the suit is pending in the court having jurisdiction to grant the relief claimed, but the plaintiff cannot go to different court and file the suit again. This is res subjudice. So nature and scope includes suits only and does not include passing interim orders. So the court can the plaintiff can go to different court to take interim orders. Object. It confers plaintiff on filing one litigation only. So plaintiff can file his litigation in only one court. Conditions to attract res subjudice. There should be two suits. That is, the plaintiff has already filed a suit in a court and is trying to file the same suit in another court. Then on same subject matter he is trying to file, and the parties in both the suits are same. The defendant and plaintiff are both same. Then pending in the courts in India. So he is trying to the case is pending in a court which is in India, and the court must have jurisdiction to try that suit, and the same parties are litigant in both suits. So if these conditions are satisfied, then res subjudice will attract, and the plaintiff will be prevented from filing a different suit in another court. Case law. Indian Bank versus Maharashtra State Co-op Marketing. So no court should proceed with proceedings if previously filed and the court competent to grant relief. So if the previous court is competent to grant relief, then the other court should not proceed to entertain the suit. So this is res subjudice. Next is res subjudicata. So in res subjudice, we saw that the case was still pending, but in res judicata, the case is already decided. So if the case is already decided by a court, a competent court, then the same suit cannot be filed again in a different court. This is called res judicata. So the no court shall try the suit which is finally heard and decided by that court, which is competent to try. Nature and scope. So res means subject matter or dispute. Judicata means decided or adjudicated. So res judicata means dispute decided. Object. It is based on three maxims: nemo debit vix vexari pro una et idem causa, which means no man should be vexed twice for the same cause. The next maxim is interest re publica ut sit finis litium. It is in the interest of the state that there should be an end to litigation. The next is res judicata pro veritate acquiescer, which means a judicial decision must be accepted as correct. So conditions to attract res judicata. The subject matter in both the suit should be same. Then the parties in both the suit should be same. The plaintiff and defendants must be same. Then the litigant under same title in a former suit. So plaintiff should be plaintiff and defendant should be defendant in both the suit under the same title. Then a competent former court. The court who decided the case was competent to try it. Then the matter decided in former. The matter has already been decided by the former court. Then the plaintiff cannot file it in a different court. It is called res judicata. Case law. Daryao versus State of UP. So in this case, a writ petition in High Court of Allahabad under Article 226 was dismissed. For same relief and on same grounds, he filed another writ petition in the Supreme Court under Article 32. So it was dismissed on grounds of res judicata. Next, section 12, bar to further suit. Where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. Same as judicata. The next important concept is foreign judgment. So what is this foreign judgment? So if anyone takes a foreign judgment, is it competent in India? so that it explains. So the foreign judgment shall be conclusive as to any matter. So it is accepted in India except in certain conditions. Where it has not been tried by a competent jurisdiction, the court was not competent to try in a foreign court, then it will not be accepted in India. Next, it has not been given the merits of the case, so it has not been decided on the merits of the case. And the next is the foreign court refused to recognize the law of India, then also it will not be enforced in India. And the judgment that a foreign court gave was opposed to natural justice. And the judgment the foreign court gave was a fraud, and the judgment that the foreign court gave was a breach of any law in force of India. So they did not consider the Indian law, they breached it and they gave judgment, then it will not be enforceable in India. Except for this exception, the foreign judgment will be enforceable in India. So presumption as to foreign judgment. So it is presumed that the foreign court was competent to try if that case come to India. Case law. Narasimha Rao versus Venkata Lakshmi. So what happened in this case was, the husband, he obtained a divorce in an American court from his wife, claiming that he was a resident of America, and he married C. So B came to India and filed the case for bigamy. So SC held that a decision without jurisdiction and not enforceable in India. So American law is different for divorce, and in Indian law is different for divorce for Hindu law. So this guy A, he obtained a divorce in American court from B and then married C. So it was not enforceable in India. He was convicted for bigamy. The next important concept is place of suing. So court in which suits to be instituted. Every suit shall be instituted in the court of the lowest grade competent to try it. So if the JMFC is competent to try, then the suit must be filed in the JMFC first. He cannot directly go to a high court or district court or senior division. Types of suits. So there are in total 4 types of suits. Suits in respect of immovable property, then suits for movable property, then suits for compensation for wrong, tortious suits, and other suits. So first, for immovable property. So the immovable property, well, to file a suit in immovable property, we have to see where the immovable property is situated, its location, to which court's jurisdiction the immovable property falls. We have to see that. It covers different scenarios of immovable property, the section. So what if the property falls in jurisdiction of more than one court? Then the suit may be filed in any court which can take a full cognizance. So if the immovable property is situated in the jurisdiction of more than one court and more than one court is competent to try it, then any one court which can take full cognizance of the case, in that court we can go for the suit. If limits of jurisdiction uncertain for more than one court, then any court may record a statement and entertain the suit. So the limit is unclear to which court's jurisdiction it falls, then any one court can take its cognizance by recording a statement. The next is movable property. So where is the jurisdiction of movable property? So maxim is mobilia sequuntur personam, meaning movables follow the person. So unlike immovable property, the movables follow the person. So place of filing for movable property. So it is at the option of plaintiff. So it is at the option of plaintiff. Plaintiff can file where it is to the option of plaintiff, but where a wrong committed, he can file it where the wrong has committed to him, and where a defendant resides, carries on business, or personally works for gain. So at a defendant's location where he resides or carries out his business or personally works for gain. There is an illustration. A residing in Delhi beats B in Calcutta. B may sue A either in Calcutta or in Delhi. Compensation for wrong. It is same as a movable property at the option of plaintiff, or where the wrong happened, or where the defendant resides. For other type of suits which are not either movable, not tortious, or not immovable, so it is also at the option of plaintiff, where cause of action wholly or partly arised. Where cause of action arised, and where the defendant resides, carries on his business, or works for gain, or if there are more than one defendant, then any one's defendant's place it can be filed. There's an illustration given. A is a tradesman in Calcutta. B carries on business in Delhi. B, by his agent in Calcutta, buys goods of A and requests A to deliver them to the East India Railway Company. A delivers the goods accordingly in Calcutta. A may sue B for the price of the goods either in Calcutta, where the cause of action has arisen, or in Delhi, where B carries on his business. Case law. Union of India versus Oswal Woolen Mills Limited. So the registered office of the company is in Ludhiana, Punjab. Petition filed in High Court of Calcutta. Court to pass interim order relief as ex parte. Supreme Court has set aside the order. So the defendant residential was in residential address was Punjab, but the petitioner, he filed the petition in High Court of Calcutta. So that's why Supreme Court dismissed the order. The next important concept is the transfer of cases. So who may apply for the transfer of cases? Obviously it is the defendant who can apply for the transfer of case. If there are more than one court which can try the same suit, then a defendant with the earliest opportunity can apply to have the suit transferred to another court. So to which court he should apply to transfer? So if a courts are subordinate to same appellate court, then to appellate court. So he has to go for the higher court. Like a Supreme Court can transfer the cases of High Court, and High Court can transfer the cases of district courts. District courts can transfer the cases of their lower courts, etc. The next, the power to transfer. On application after notice to parties, the High Court or District Court may transfer suit or appeal proceeding to competent court, or they can even try to dispose it, or they can withdraw the suit and try to dispose it or transfer it to another court. Power of Supreme Court to transfer cases. On application after notice to parties for ends of justice, Supreme Court may transfer from High Court to High Court, District Court to District Court, and this must be supported by an affidavit. Case law. Jagadguru Sri Shankaracharya versus Ramji Tripathi. So plaintiff's right to choose own forum should not be interfered except on strong grounds. So if the appellate court wants to transfer, if the defendant wants to transfer the case from to different court, then the court can only do it if it has strong grounds. So this concludes the first unit. Thanks for watching.